It started with a few very troubling allegations against a substitute teacher out in Indiana, but now that case has exploded into one of the most disturbing sexual misconduct scandals we have ever covered. Former teacher Brittany Fortinberry is facing even more criminal charges after yet another alleged victim came forward. And remember, this is the same case where boys said she organized group sex sessions at her home, forcing them to wear scream masks. So what do these latest counts mean for her defense? How much prison time could she actually be facing? We're going to break it all down for you right now with an Indiana criminal defense attorney. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now, if you've been following us here on Sidebar, you know that we have been digging into some of the most disturbing teacher misconduct cases in the country. I feel like we talk about one like every week. Well, I will tell you, we are back once again, not with somebody new. No, it is somebody we've talked about a lot, and now we have more shocking updates. It is the case of Brittany Fortinberry, okay? She is a former teacher, substitute from Morgan County, Indiana, and she is now facing a staggering 47 criminal charges. That is a number that just keeps on climbing. This comes after yet another alleged victim has come forward with disturbing details, and we will get into all of that in just a bit, but we gotta catch you up to speed on how we got here, because I will tell you, fair warning, this timeline, it is chock full of horrifying allegations. I'm talking everything from accounts of molestation to sexual misconduct, incest charges. According to the Metropolitan School District of Martinsville, Fortinberry started working in the district back in October of 2023 as a substitute teacher and resigned in January of 2024. But here's the thing, the district said that that resignation wasn't due to sexual misconduct allegations. Fortinberry then began working for the Eminence School District in July of 2024. In August of that year, she resigned, and she resigned after allegations surfaced that she had been exchanging explicit messages with a student. Now, if these allegations are true, you would hope it would just end there, but according to authorities, that is just the tip of this very unfortunate iceberg. This is where the criminal allegations began to pile up. In the first police reports filed in September of 2024, investigators said victims described Fortinberry as manipulative and persistent. One 13-year-old told police that she would text him constantly and that she threatened to harm herself if he stopped responding. Another teen said she gave him marijuana and alcohol at her home before forcing herself on him in the garage. And what makes this all even more disturbing is that these weren't just secret interactions happening behind her husband's back. Yeah, married. No, court documents suggest that Nicholas Fortinberry didn't just know about this behavior. He allegedly became part of the intimidation. Detectives say that there was one victim who told them about a moment at the Fortinberry house when Nicholas returned from work, had a private conversation with Brittany, and then confronted the teen face to face. The affidavit says that the victim was left terrified. According to the report, Brittany had already told him that she would do something bad to herself if the truth came out, and warned that Nick would slaughter him in front of his family. A few weeks later, the boy says Nicholas delivered the threat himself. According to an arrest affidavit from March of 2025, alleged victim also mentioned that Brittany had shared that if any of this came out, that she would herself. Alleged victim said Brittany told him that if anyone found out, that Nick would slaughter him in front of his family. Alleged victim said about a couple of weeks after Brittany told him this, that Nick made the threat to him. Other alleged victims describe how she bought them gifts, spent hundreds on shoes and clothes, and then pressured the boys into sex. At least one victim reported she paid him as much as $800 for nude photos. And then came the most bizarre detail of all. Boys had said or alleged or claimed that she organized group sex at her home, where she required them to wear scream masks from the movie and rotate every 15 minutes. Now, initially, Fortinberry was charged with a handful of felonies in late 2024, but by February 2025, prosecutors had filed 29 counts. This included sexual misconduct with a minor, child molestation, dissemination of harmful material contributing to the delinquency of a minor, and the pattern allegedly continued. In May of 2025, another victim came forward, alleging Fortinberry invited him to her home, gave him drugs, coerced him into sex while her own children were in the next room. That pushed her total charges up to 41. And by then, prosecutors said at least 9 victims had been identified. Hey everybody, this is another Law and Crime legal alert. There are allegations right now claiming that the online apps DraftKings and FanDuel are engineered for addiction. That's right, these multi-billion-dollar companies allegedly continue to put profit over safety. Every free bet, every boosted parlay, every small payout triggers a dopamine rush, and that allegedly creates dependency and turns harmless fun into a detrimental habit. They allegedly keep you hooked, chasing impossible wins, and can trap you in a cycle that can lead to significant financial loss and ultimately damage mental health. Well, I'll tell you what, our legal sponsors, they are taking on the online gambling industry to potentially get compensation for all of those impacted. So if you or a loved one has suffered addiction or financial hardship or mental health issues due to sports betting apps, then visit gamblinglawsuits.com/sidebar to take a short quiz and check your eligibility to file a claim. So you fast forward to where we are now, September of 2025, when a 10th victim came forward. Yeah, according to new court filings that are obtained by Law and Crime, this boy told investigators that Fortinberry first invited him over just to hang out, do drugs, and then it escalated. And that led to the 6 newest counts, bringing her total to what, 47? 47 charges? We're going to work our way through these horrific allegations laid out in this new affidavit. And to help us do this, to parse through what exactly this all means and what we can expect with a criminal case like this, whether or not it's actually going to result in a trial, maybe there'll be a plea, I want to bring on a special guest, Indiana criminal defense attorney Andrew Baldwin. Andrew, thank you so much for taking the time. It's good to see you again.
Good to see you, Jesse.
With, 47 charges spanning multiple alleged victims over nearly 2 years, I got to ask, what are the biggest strategic challenges for a defense attorney in a case this complex? And I guess the question becomes, what is that conversation between a defense attorney and a client who's facing a mountain of evidence and a mountain of charges?
Oh, those are great questions. First and foremost, under the legal theory that we learn in law school, where there's smoke, there's fire. You have to worry about all of these charges being put in front of a jury, and a jury might find some of those charges like, I don't know if I believe that guy, or those facts aren't exactly what we thought they would be when compared to other facts. So I would normally find that guy not guilty as a juror, but because all these other charges exist, I think I'm just going to have to find him guilty. Those are the things that we worry about. And so one of the early things that should be going on right now is a real legal analysis of each individual charge, each individual alleged victim, and to determine whether or not you can separate those charges out. And that benefits you strategically in a number of ways. One way is you'd love to go to the prosecutor and say, hey, if I'm successful in severing these counts, you're going to have to try about 5-6 jury trials. Do you really want to do that? Do you really? Or can we work out an agreement? So that is important stuff early on. And Indiana has a severance law in place that says you cannot, as a prosecutor, bring charges in just because they are similar in nature. In fact, that's disallowed. There's, of course, exceptions to that, and that's what the prosecutor would be relying on. The second thing you talked about is, what about that tough conversation? Yeah, sometimes we defense lawyers, we don't learn information from our client early on until we get all the facts. But on a case like this, you might want to have a sit down in the jail with your client and say, hey, while we have leverage right now, let's try to work something out, unless you're going to tell me that you are completely innocent. If you're completely innocent, then there is no good deal. You got to go to trial. But if you are completely innocent or aren't, then maybe we should look at possibly trying to get this matter resolved now. And you do have leverage, more leverage, I think, at the beginning typically than you do at the end on a case like this.
That's really interesting because you handle that it's interesting to think about the number of charges, right? From one perspective, you could go from a prosecution point of view, there's an advantage to them, but I think that was important how you highlighted it could actually be a disadvantage if there are weaknesses in some of those charges that may make a jury skeptical of the entirety of the case or a lot of the case. But also, if the defense attorney's saying, hey, listen, we're going to keep filing motions to sever this case. It's going to take up more time. You might have multiple trials. There might be an incentive for them to drop them. Also having that conversation with your client. I guess the big question is, if you're talking about these kinds of allegations, coupled with allegations of threats, intimidation, manipulation, what is the evidence that is going to be the most important? And what is that evidence that you'd be most concerned of for a defense attorney's perspective, for a defense perspective? What is that evidence that you're most concerned about?
It's the children. It's their testimony and how they appear when they testify. These are older kids. I mean, they're now in 14, 15, 16, other than her own child, who I think is like 8 or 9 now, maybe 10. But the rest of them are teenage boys. That's far better than going in with teenage girls, by the way, just because juries view men and women differently. That's just a fact. Still, you don't want to go in with very compelling testimony of these kids that give great detail. These probable cause affidavits provide a lot of detail that, great lies are composed of great detail, okay? And great liars know how to lie by adding detail, but that doesn't mean that they're lying. That also could mean the detail is because they're telling the truth. And so how do they testify? Well, in Indiana, we get to depose victims or alleged victims of any crime, including sex crimes, as long as they're over the age of 15. So if they're 16 and older, which I think most of these kids are by now, and if they aren't, I would want to stretch this case out until they are, because I want to depose them and see how are they going to appear in court. Are they smiling a little bit when they're testifying as if, oh, this was not as bad, but maybe it's nervous, or maybe they're crying and upset, and you're like, oh my gosh. Sometimes I walk out of a deposition and I'll be like, this case is over. Or sometimes, and that can be over either way. Like I just had a sex offense case down in southern Indiana where I walked out and I thought, oh, this case is over for the prosecutor. But that's, Jesse, the answer to the question. The most damaging evidence is the child's testimony and the child himself.
Yeah, and it's tricky. It's tricky cross-examining those children or those alleged victims on the stand and how to come out to the jury. I want to get into, I have a lot more questions about this, but I do want to get into the latest round of allegations here. So the alleged victims, they're not identified in the complaints as all the names are redacted, but here is what it says. So this is according to the new supplemental probable cause affidavit that was filed on September 11th. So this alleged victim told detectives that he met Brittany Fortinberry through a friend, and that while things seemed pretty normal at first, she was overly complimentary, she was touchy, those are the allegations, and he told police, quote, Brittany was a little touchy, like on his arms, and that Brittany would always compliment him. Alleged victim said that Brittany complimented his hair, asked once to braid his hair, and told him he had the perfect hair. The victim then told the detective that the situation escalated one night in the garage. He said he was under the influence of drugs that he says she provided, and according to the probable cause statement, quote, Brittany asked him if he wanted to come feel her boobs. Alleged victim said he was stoned. He thinks she gave him shrooms and was kind of loopy, and he said, why not? Alleged victim said that she started feeling up on him and that things escalated after that. Now, the portions where the alleged victim describes the sexual encounters are just so graphic that we're not going to get into them, but we'll kind of sum it up here. He says the two of them had a sexual encounter in Fortinberry's garage, that their communication even extended into social media, with Fortinberry allegedly sending him nude pictures on Snapchat. The victim told police that the sexual relationship ended when he became uncomfortable after learning about other boys. Quote, alleged victim said the sexual stuff with Brittany stopped after he started getting uncomfortable. Alleged victim said he was one of the first people going over there, but after he heard about 3 other people after he had been with her, he was done. He summed it up by saying she just handed it out to anybody. Now, Andrew, all of this allegedly happened over a maybe 3 to 4 week period in September of 2023, according to this statement. It's pretty damning accusations, to say the least. And also, if you think it's coupled with digital evidence, how do you perceive it? What are your takeaways here?
Well, one other thing, having read that new probable cause affidavit, it does give you that detail that we defense lawyers dread most of the time. And so that would be of concern to me. Should I depose this underage person? Again, deposition work is so important in these cases. Maybe you'll see some cracks in his story. And that could often come from the phone. They did do a phone dump. The police asked for the accuser's phone. They did a phone extraction. And the accuser, did say, hey, she sent me this and she sent me that. And, you can look at old things that have even been deleted on a Celebrite phone extraction or Gray Key or whichever one that they use. And maybe you as an attorney can say, hey, he said this happened. It doesn't show up on the phone. How can we trust anything this kid says? Is he just going along because he didn't get the attention that the other kids got? Could it be something like that? And boy, that's some icky territory to get into as a defense lawyer. Really would not want to do that at trial unless it's very plainly obvious, because you can lose a jury very, very early on.
By the way, that level of detail, I mean, it's so specific. I always wonder in these kinds of accounts, does that work for the prosecution? Because a jury could say that's so detailed. How could someone, make any of that up? It has to be true. It has to be real. But other ways that defense attorneys could work through it as well.
Well, in a case like this, when there's multiple victims or alleged victims, if there's a similar story among all the alleged victims, then you could, as a defense lawyer, try to say, hey, these guys are all telling the same story. So that's where they get the detail. But man, no, I do not want that detail. I mean, if I can avoid the detail, I like accusers in cases like this where it's very, very generic information and they're not saying, well, then we went into this particular room and sat at this particular chair, and they detail everything. And it's hard to believe that people can make up stuff that much detail. So no, I don't think it's good. But the detail can hurt a case if, again, there's something else to compare it to. And the most common thing nowadays is the phone, or the computers. And if they're saying that I was in a certain place on a certain day, and you can get a kind of a photograph that was taken on that day, and it's 100 miles away, then all of a sudden you have something awesome to work with. They provided that detail, and now they're a liar. So, yeah, but you got to dig in as a defense lawyer and look for those problems.
I want to go into the new charges, because here's the quick breakdown according to the court docket. So 3 additional counts of sexual misconduct with a minor, 1 charge of dissemination of harmful matter, 2 counts of contributing to the delinquency of a minor. Andrew, when you look at those charges, some of them feel quite broad. It can encompass a lot of different conduct. What do you take away from those specific charges? And again, I go to the defense perspective here. Are there avenues to fight against them? I do wonder what would be the defense's strategy here, other than trying to strike the credibility or trying to work out a deal. Those specific charges, anything stand out to you?
No, it's kind of from a prosecutor's perspective, throw everything against the wall and see what sticks. And I understand it, because sometimes some facts, you never know what's going to happen at trial. And sometimes you expect a witness to come in and say something, and then they don't say that something. And all of a sudden, one of the counts that you really counted on is gone. So you throw in as many counts as you can. And in the sex offense criminal world, there's a variety. There's a whole section in Indiana law that covers a lot of ground. And so it's not surprising that they ask for all those charges to be filed. In addition to just those charges related to that accuser, it's also that those charges with that accuser are being added to all these other charges with all these other accusers. And it's, again, where there's smoke, there's fire. These are things you have to worry about. And, from a strategy perspective, you said, what can you do? outside of doing this deposition work that I keep talking about, Indiana is one of, like, I think 5 or 6 states that allows depositions in criminal matters. And it's a huge help to both sides. It usually helps things get resolved because either side can say, my guy's credible or my guy's not credible. But beyond that, when all these people are on there, now you got to start looking at each individual accuser and their situation. Do they want to go to trial? Are their parents angry? Will they be willing and amenable to a plea? These are things that I actually ask at a deposition often at the very end. What do you want to have happen to this person? And if I want the book thrown at him, I want him in prison the rest of his life, that's one thing. If they're like, I don't really want to go to trial, I'm nervous about that. Now that's a little inside information you can use during plea negotiations.
Yeah, let's talk about that real quick. What would be an advantageous plea for prosecutors here when they're essentially accusing her of being not only a sexual predator, but a monster? What would be a plea that would be acceptable for the community and for the alleged victims here without going to a trial? I get it, not have to put these people on the stand. It's painful. It's time consuming exposing a jury to all this. If you can spare it, I get it. But what would be a reasonable, probable plea offer that prosecutors would accept in a case like this?
That's a great question, and it really depends on the prosecutor and how they think and how they operate. Are they, for example, bothered by pretrial publicity? Are they worried that if they are too lenient in some way that's going to come back and bite the prosecutor's butt at election time? So they have to worry about that. That's one thing, but also these are human beings too, and prosecutors have kids and they put themselves in the shoes of these parents. And so what is a reasonable? Well, that is in the eye of that particular prosecutor. I will give you some examples of what I think would be reasonable is once you as the defense lawyer have gone through the charges and gotten a pretty good feel for what is provable beyond a reasonable doubt and what isn't, then you might go to the prosecutor and say, what are you most concerned about? Are you concerned that every alleged victim he's found guilty related to every alleged victim, or are you talking about, do you care about time? Do you want this person to be in prison for a long, long time? Or do you care about the charge that they plead guilty to? Because, for example, there's, I think, 9 felony 4s charged. That's 2 to 12 years on each. 12 times 9 is 108. That's 108 years. With an F4, when you go to prison, you have more freedom. You're able to move about more easily. You're open to getting some different treatment and things that you're not eligible for as an F1. F1's more serious, 20 to 40 years. So sometimes what I'll talk to clients about is, if we lose and you're hit with this F1, you're basically going to be in lockdown and you're not going to have any type of life. However, if you go in on F4s that add up to an F1, then you're going to have some type of life in prison. And so you have to have those really uncomfortable conversations. Yeah. And I would say that's where maybe the action is. Hey, can we plead guilty to a bunch of F4s that add up? And we call this in Indiana or other places probably too, a floor and a ceiling, where we know the judge gets to make the decision, but this person's going to do at least, let's say, 10 years. But no more than 30 years. Can we work within that confines, Mr. Prosecutor, Miss Prosecutor? But I don't want him pleading guilty to F1s. We might as well go to trial if you're going to do that. That's the type of conversation you have behind closed doors with prosecutors.
What about the case surrounding her husband? So Nicholas, we talked about this before. He is charged with intimidation, failure to report. We mentioned earlier how one victim claimed that Nicholas threatened to literally kill him if he ever spoke about what happened. He's out on bond. He has a jury trial scheduled later this year. What do you make of the case against him?
That's a much better case. I mean, he was telling the kid that he threatened allegedly to not do this with his wife anymore. So it's a kind of a weird argument, but you could say, hey, he was trying to do the right and honorable thing. It also kind of shows that he has knowledge, on the other hand, of what might be going on, but he's not approving of it. And I did read in the new PCA, the new probable cause affidavit with that new child, something that really stuck out to me was this new alleged victim says the dad didn't know she was giving us all these drugs. So that could be useful. As a prosecutor, you might go to the dad and say, look, we don't really care about you that much. We just want you to testify. And maybe that's how it gets resolved. I don't know that he has. On one hand, I'm trying to sit here and think about all these probable cause affidavits, Jesse, as you know, you've read them. They really paint a picture of like a chaotic scene where just young boys are at this woman's house all the time. How can this guy not know that? But on the other hand, if he's at work a lot, and the other weird thing that this kid said that the Brittany Fortinberry brought these kids to his workplace at the fire station, which I just thought was bizarre too. Why is she doing that? And it maybe makes him look more culpable. I don't know. So I don't know that he's facing like real time here, jail time with his charges. I think his case probably gets resolved one way or the other, short of trial.
It's just another shocking component to this story. I want to go back to Brittany's defense, though. So her defense team. They have filed notice of intent to use a mental illness or defect defense. They're asking apparently for psychological evaluations to determine whether she was competent at the time of the alleged crimes. And according to that filing reviewed by WTHR, counsel has a good faith belief that the defendant likely suffers from a mental disease or defect, but lacks the expertise to proffer whether the defendant appreciated the wrongfulness of her conduct at the time of the offense. Such an opinion must come from qualified experts pursuant to statute. Andrew, you and I both know that a mental health defense can be an uphill battle. I'm also not surprised that that is what they may be going with if they can't go with, or they may have trouble suggesting all of this is a lie, none of this happened. This may be, I don't know, for lack of a better term, a Hail Mary, but there could be something legitimate here. Your thoughts on the legal standard in Indiana for this kind of defense and whether or not it would be successful?
I think it is incredible, as you just said, it's incredibly difficult to win on mental defect type of. Some people used to call it the insanity defense. Especially, there's some discussion in the probable cause affidavits where Brittany is saying, please don't tell anybody what we're doing or I'm going to kill myself. And that shows that she appreciates the seriousness of the crime. She knows it's a crime. And that's the type of thing that in Indiana, you're going to have at least, I think, 2 psychologists are going to interview her. And that's danger, by the way, because anytime you have a psychologist go into her jail cell and you're opening yourself up to her just making even more damaging admissions, I don't know that she has made any yet, but when you do ask for and seek a mental health type of defense, you're basically saying, hey, doctor, go in there, interview her, and then he's going to come out and say, yes, she appreciated it. No, she didn't. But while we're at it, here's a bunch of stuff she said. And that really helps the prosecution out typically. So you got to be very, very careful when you make that request, as the defense apparently has done.
Does this come down to, like you said, like a battle of experts? You have the defense's psychological evaluators, you have the prosecution, and I would imagine that just delays this case even further.
It could. There's like in Indiana, there's like 2 or 3 of these psychologists. This is what they pretty much do every day. They go to different places, to different jails, and they interview different people, and then they put out different reports. It's pretty rare for a defendant to have their own expert. Actually, they usually are using the experts that the judge hires for the case. But yeah, it could be a battle of the expert if she has enough money to hire her own experts. But these experts, it's not like it's hard to find these, what some people call, paid, who are going to, I don't want to use the word, but who come in and just make up a story.
You want me to say it? What they say in
Sure.
every kind of trial? A hired gun?
A hired gun, that would be a way to say it. Yes, that would be a way to say it.
It's not, I don't like the term either, but that's what's used.
Yeah.
That's what's used. Yeah.
Yeah, I mean, but it's hard to, most of these doctors and psychologists, they have a reputation. They don't want to be thought of as a bad, a bad person that makes their decision based upon money. So, it looks really bad when you hire an expert to go into the jail and talk to them, and it's pretty much going to be known that you've done that, and then you don't tender a report to the prosecutor. Well, I wonder why. I wonder what the expert said. I mean, there's just all kinds of problems when you get into that world. And I'm not saying, hey, we have a number of cases in our firm where we're using that defense, and it's valid, and we believe in it. But when it's used as a Hail Mary, as you said, it can really lead to other problems, unanticipated problems.
Talking about problems, I mean, what began with a handful of charges, it is now snowballed into one of the most shocking abuse cases, I think or alleged abuse cases that we have ever covered and ever seen here on Sidebar, and it is still growing. Andrew Baldwin, thank you so much for taking the time. Really, really appreciate it. You have terrific insight and obviously a phenomenal defense attorney trying to, talk about different scenarios here. So thank you for taking the time. Really appreciate it.
Great to see you again, Jesse. Thank you.
And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll see you next time.